Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is maintained for the jurisprudence students. Friends, you all know that jurisprudence means the skill of law, knowledge in law, and the things we know which were enunciated to frame the present law to this stage. Yesterday, it was published in Hindu regarding a new concept called as sealed cover jurisprudence. Sealed cover jurisprudence, which is appalling, which is becoming a dangerous trend, which may become a dangerous precedent also. Sealed cover jurisprudence. How this is happening? Friends, about 1 month back, I made a video on Kerala High Court decision on Media One, which is a news channel. So Media One is a news channel, and in view of the state of our central government, they are propagating a particular something that is like a Muslim, this thing, Jamaat-e-Islami propaganda is there, anti-national. They are propagating anti-national thing. Therefore, previously they have given a notice to this particular channel that you should not propagate in a negative way to the so-called Bharat or Hindu. So much things are there, but they did not hear. It's quite common. Therefore, the government of India refused to renew the license. Refused to license to exhibit the so-called Media One. So now they cannot air their programs. This is the situation. They went to the Kerala High Court, then appeal matter went to Supreme Court also, and ultimately what happened is, when they asked for affidavit to be filed by the center, because the media, entire press or electronic media is under the control of Ministry of Information and Broadcasting. So they stated that they will file the information in a sealed cover because it entails the national integrity or security of the nation. So therefore court agreed. They have furnished the information in the sealed cover. The sealed cover discloses that this channel is propagating a lot of material against the integrity of the nation. Therefore, it should not be continued. Now, the court is satisfied with the sealed cover information, and they did not want to interfere. Even the court, High Court and Supreme Court also, same situation. Now the question is, what about Article 19? Freedom of speech and expression. No doubt, Article 19 Clause 2 is there. Test of reasonability is there. Of course, by airing the opinions, you should not hurt the sentiment of the Hindus or others. This is there. But what happened? What was there in the sealed cover? This should be, is it not the duty of the court to inform the other party the information? This is not informed. This is where fair trial, free speech, all these things are coming to existence. So, if something is written in the sealed cover and the court is believing it, then what is the purpose of cross-examination? What is the purpose of public inquiry? What is the purpose of Section 309 CRPC, 327 CRPC saying that court is open? No. So, if somebody gives information in a sealed cover and we are accepting the same, it is against it. Is it not against to Article 19(1) of the Constitution? So, this is the fundamental question raised by some advocates, and as a press item it has come. So, please remember, the jurisprudence of the sealed cover is an appalling trend. So, the process of judicial review, definitely it is significant since it holds the executive accountable. Yes, judicial review, in sometimes judicial review, definitely it will enter the domain of the executive, but it makes them work, is it not? So likewise, the sealed cover jurisprudence is it is giving a dangerous spirit, because the Constitution does not give a free hand to the executives to give information in the sealed covers. So previously, please remember the decisions in Minerva Mills, very famous case, 1980, Minerva Mills versus Union of India, 1980, L. Chandrakumar versus Union of India, 1997. For example, what is this after emergency? ADM Jabalpur, yes, ADM Jabalpur case 1976, please remember. The fundamental rights, they have to be definitely respected. Yes, if there is any adverse information, even according to the principles of natural justice, the other party should inform it. So there is information that threat to the integrity is there. Basing on these points, that point should be at least known to him. Even not public, at least the other party should know. Without knowing, simply basing on the sealed information, if you are not going to give the judgment or if you are going to adverse judgment, how can it be not violative of Article 19? So this is what is the important point here. Even in Pegasus issue, as you may be knowing, in the Pegasus issue, the central government stated we are filing only brief affidavit, we are concerned with the security of the nation, we don't want to divulge this information. And then Supreme Court did not accept it. Pegasus case, Manohar Sharma versus Union of India, I think that case, 2000. So Supreme Court has categorically held that the state does not get a free pass every time. The state, that means center, does not get a free pass every time, saying that the specter of national security is raised and national security cannot be bugbear that the judiciary shies away from. What is that national security? The court has to know and it has to be informed. Otherwise, please remember, this process of allowing the sealed cover information, if it is continuous tomorrow, it may become a jurisprudence. So tomorrow, the courts may allow the sealed cover information, so which should not be there. It is against to Article 19(1). Anyway, it depends on, of course, it has not framed it has not become law, but still it is under discussion. So friends, please express your opinions whether sealed cover jurisprudence may be allowed or may not be allowed. With this, I want to conclude. Thank you very much.